Good morning. Welcome to today's meeting of the Assembly Committee on Government Affairs. Will the Secretary please call the roll?
Assembly members Carter,
Present.
DeLong,
Definitely here.
De Silva,
Here.
Edgeworth,
Present.
Flanagan, Gallant,
Here.
Golding, Gurr, Hunt, Jackson, Karras, Kasama, Nguyen, and Chair Considine.
And I am present. Thank you. Well, let's get started. Welcome to the audience in Carson City, those joining by video conference in Las Vegas, and those listening over the internet. I would like to begin with some housekeeping measures. Please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. While testifying, please turn on the microphone and clearly state your name and any affiliation for the record. Turn the microphone off each time you are done speaking. If you are providing handouts, please ensure that hard copies are available for the members of the public. Electronic copies should be submitted to our committee manager by 9 a.m. the day before the committee hearing. We expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. I encourage committee members to ask questions and engage with the material presented. If you have any follow-up questions, please flag them for me so we can ensure we balance our time effectively during the meetings. And committee members will be using their laptops to view handouts and other documents. Please do not interpret this as a sign of disrespect or inattention. Today, we will hear one bill, Assembly Bill 208, which restricts the use of certain products by governmental entities and government-funded entities. But before we start the hearing, we do have a BDR introduction. We will introduce BDR number 36393, which revises provisions relating to artificial intelligence. Remember, voting in favor of introducing a BDR does not imply a commitment to supporting the measure later. All this action does is to allow the BDR to become a bill and enter the legislative hearing process. I will entertain a motion to introduce BDR number 36393.
So moved.
Okay, so Assembly Member Vice Chair Nguyen made the motion, and then I heard a second from Assembly Member Flanagan. Is there any discussion? All those in favor, say aye.
Aye.
And all opposed, say nay. Okay, the motion carries. Thank you. Okay, we will now open the hearing on AB 208. To present this measure, we have our Speaker Yeager and Attar Hasibullah. Please go ahead when you are ready.
Good morning, Chair Considine, Vice Chair Nguyen, and members of the very hardworking Assembly Government Affairs Committee. My name is Steve Yeager. I represent Assembly District 9, which is in Southwest Las Vegas, and it is an honor to appear in front of you this morning to present my first bill of the 83rd legislative session. With me at the table, many of you know, is Attar Hasibullah, Executive Director of the ACLU of Nevada. I'm going to make some sort of brief remarks about the intent of the bill and what it seeks to do at a very high level. And then Mr. Hasibullah is going to be kind enough to go through the bill itself. And I will note that there is a proposed conceptual amendment that I believe you should all have, or at least was up on Nellis. And it vastly limits the applicability of the bill. As I said, Mr. Hasibullah is going to go through that in more detail, but we're essentially asking to limit this bill to the most vulnerable Nevadans who reside in state institutions, those who are not able to seek second opinions when it comes to medical treatment. So Assembly Bill 208 has the goal of protecting the continuity of care for vulnerable populations. Many Nevadans depend on life-saving drugs for conditions like diabetes, epilepsy, multiple sclerosis, and mental health disorders. Assembly Bill 208 ensures that incarcerated individuals who rely on lifelong or necessary medications receive the correct, medically appropriate treatment rather than outdated or off-label substitutes chosen solely for cost-cutting measures. This bill aims to prevent the misuse or mismanagement that could negatively impact patients, particularly those in mental health and correctional facilities. There is a need to prevent off-patent use on those in state-run facilities and institutions, which can be done through the protection of on-patent use. The idea here is let's use the right medication for the right job. In addition, we have some uncertainty at the federal level, as all of you know from being in this building the last few weeks. Federal agencies have increasingly left enforcement and regulation ambiguities up to the states, making it imperative for Nevada to establish its own standard for consistency and safety. Federal restrictions could cut access to these medications due to patent disputes, regulatory review, or changes in federal policies. With what I believe is partly chaos and partly uncertainty happening at the federal level, Nevadans need to provide stability and peace of mind for our constituents. With fluctuating FDA guidelines and access restrictions to certain medications, it is crucial that Nevada has a clear framework to protect its residents to get medically appropriate care. So that is the framework of the bill. And Madam Chair, if you would allow, I'd love to hand it over to Mr. Hasibullah to take you through some of the technical details. And then, of course, we'll be available to answer what I'm sure will be several questions on this measure.
Sorry, they're touch buttons, yeah. For the record, Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I serve as the Executive Director for the American Civil Liberties Union of Nevada. I want to thank you all for hearing this bill, and thank you to the Speaker for agreeing to offer this up. The iteration behind this, and conceptually, I know there was some questions I've heard from a few lobbyists, chatter about, what is this bill meant for? What is it designed to do? And I'm going to attempt throughout my speaking portion to be as minimally hyperbolic as I can in the overall course of things. When the Speaker had reached out and his team reached out several months ago to us, they had asked us, what are we hearing from community members? This was about 6 months ago or a year ago. And one of the consistent issues we face at the ACLU of Nevada is I get letters about 3 to 4 times a week from people who are institutionalized in Nevada facilities that complain about medical treatment and the care that they've received. But beyond that, about the items that they should be receiving that have been discontinued, items that were supposed to be used in a specific fashion that are not being utilized in that fashion. I'll mention a couple of those without going into too much specificity to protect attorney-client privilege as well. It's very tough to read those letters every week, multiple letters like that. And unfortunately, the reality is this is not, and I won't ascribe blame when saying this to any government entity. The reality, though, is that the system's broken, and we're seeing people get sick, and we're seeing people in a tough position find themselves in a worse position. I'll give examples. We've received complaints about heart medications that were supposed to be used for continuous terms, lifelong care, that were restricted thereafter. And those individuals were not able to use those anymore. We've received the same with respect to antipsychotic medications that in a very difficult setting like that are very much necessary. We've seen the same with respect to devices. When I say devices and products in that regard, things as basic as hearing aids, where individuals haven't been provided batteries for extended periods of time. It shouldn't require the ACLU of Nevada's intervention to jump in there. But we know also these cases are not lucrative cases for private practitioners to take on. We do this because we want to improve the quality of medical care, and we recognize these departments are facing their own challenges. Each of these entities, whether it's a state-run prison or state-run mental health facility or institution, consistently doesn't have enough resources to be able to do what they need to do. So we understand the challenge that goes in there, but for the individuals that we serve who are most vulnerable community members, it creates a challenge. So I wanted to lay out the framework for that as the initial iteration and the concerns we address. But there's been a new set of challenges that I think we're facing right now, which is what happens when this body's not in session. And we're in August or September of this year, and certain medication has no longer been restricted for prescription by the FDA, but Medicaid access or the ability to cover those meds has been cut off. We've all seen what's happened with respect to potential freezes in funding and the chaos it causes, to the speaker's point. And again, the federal government, the president's entitled to do what he wants in that regard, but for the people that we serve, we don't want to see any of those items cut off, and we don't want to have to beg for a special session for continued care for a medication that was otherwise being utilized for long-term care, but has since been restricted because coverage doesn't exist to pay for those items thereafter. So we find ourselves in a unique conundrum without a full-time legislature to intervene on those types of issues. Our goal is straightforward here. At the ACLU, we hope to avoid having to litigate these issues long-term. This is not something that we're aiming to do, take on each of these cases because someone's facing these types of issues consistently. It becomes a systemic issue at that point, and the real recourse that's associated with it is heavily problematic. So we're doing what we can at this point, and hopefully via this legislation, to mitigate against some of those concerns so that we can be proactive. We don't want to find ourselves in litigation with the state on these types of issues, because at the end of the day, large settlements paid out by the state of Nevada impact all of our ability to see better functioning state as a whole and the rest of our social sector. So I did want to thank the speaker for his willingness to do that and his proactivity in making sure that continued care, at least for a body that's only able to convene 120 days every other year, will remain stable. I'll walk you now through the actual bill language and then the amendments, and happy to take any questions on it. I also recognize that there are those that have made offers and suggestions. We're happy to work with everybody along those way, but make no mistake that the reason why this bill is here is to make sure that people are protected against misuse. So the section, and I won't go through every section, I'll give the overalls, and again, happy to take questions there. The amendment, I think, should provide a lot of context there. And actually, I'm going to cover the amendment first, because I think the amendment probably mitigates a lot of the concerns that end up coming forth here. Initially, when the bill was drafted, it applied to all government entities and all government-supported entities or government-funded entities, which, as we had defined previously, received 50% or more of their operating budget from the government. Since the bill's been restricted to our mental health facilities that are operated by the state, our correctional centers, as well as our mental health centers. Those statutory provisions are contained within the conceptual amendment there. Theoretically, it could have a broader impact on all people, but I think right now our biggest concern in the letters that we received, which is why we reached out to the speaker's office on this and had that conversation, was because of those that are confined. And again, proactively looking at this, the other reason why we limited it here was because the biggest challenge that we have with respect to the amendment, again, if there's a cutoff, we don't view a cutoff as necessarily being an FDA approval, but an inaccessibility to be able to access those drugs in a facility where Medicaid isn't covering and a person doesn't have private access to health insurance that otherwise might cover very expensive medication there. So we've limited the entities that are covered by this. We've also limited the government-funded entities to say that the contract that would need to be engaged in would be with respect to these types of entities, the same three I mentioned: mental health centers, mental health facilities, and state correctional facilities, or anything that falls within those specific chapters. So it is very limited in that regard. And then finally, the governor's office did reach out to the speaker with respect to Medicaid considerations, and one of the considerations and concerns was a cutoff of Medicaid funding if there was noncompliance. So what we did was we included language that said the state is able and should cooperate with the federal provisions, should not violate federal law. But if somebody who is institutionalized in that setting cannot get access to an item that was required, that they needed before, that they had a prescription for, or a device that they weren't able, that they need, that they should be able to continue to use, and that is no longer available within that facility because Medicaid is no longer covering it, that person should work with the department or the facility to be able to access that medication through a licensed pharmacy or retailer or anything else outside of the facility to make sure that that's not cut off. Part of what we run into, as you might imagine, is bureaucratic challenges when we have to go through items like this. I see a couple of nods. I'm sure folks have heard over the years about the bureaucratic challenges that exist when we're dealing with layers of government. So we're hopeful that that at least helps mitigate against some of these efforts, and that the continued care for some of these items is not cut off. Then we go to the actual, those are the portions of the amendment. We go to the actual bill itself. The bill does a few things. It defines what a federally reviewed product is. Primarily the focus was on patents, but it's also those that are seeking patents. And the reason why we included this specific definition, folks might not know, patent terms expire relatively quickly. They're not for permanency when we're discussing intellectual property that ends up existing there. So we've defined federally reviewed product. We've provided for what the potential uses would be and where use would not be permitted. Specifically, if it is inconsistent with the written directions, instructions, limitations, or intended usage for that product. I will say we've spoken to few pharma companies over time as well. And I'm not the lobbyist for Big Pharma, so let me make that point clear before anybody on Nellis or elsewhere accuses me of such. But part of the concern they had was the reason why we end up having those conversations is because they end up implicated if there ends up being misuse in those specific settings. They're kind of the first line that ends up getting targeted when they created a product, right? They invented a product, they created it for a specific person. So while we certainly respect folks who may have other conceptions about how those items should be used, really what we're doing is we're shifting the burden and the onus of potential liability onto the company that created what could be a medicine that's very effective for use and is now being viewed as something that's negative because it was being used in a manner that was inconsistent with the original purpose of the product. It would also not preclude that in its entirety. It allows for whichever entity is utilizing that item in a non-conforming fashion to thereafter notify the company that they're doing so, and then that company can provide a response and say that's sufficient. So it provides that outlet as well. But what it won't do is it won't cut off access for our most vulnerable populations in a time when no lawmaking is being done at that level. Certainly, I'm always happy to sue the state. I would prefer not to, primarily on this issue, because lawsuits don't actually save lives in this particular instance. What will save lives is good policymaking and forward thinking when it comes to mitigating against some of these effects. Put into perspective some of the federal policies and why we specifically are concerned about it. I know some folks have said, well, there's not going to be medication cut off. There is an executive order specifically under the Make America Healthy Again Commission, or that particular provision specifically addresses studying the efficacy and impact of antipsychotic medications. I would offer that cutting someone's medication off that needs antipsychotic medications is actually far more dangerous from a public safety and public health perspective than maintaining someone on it. So I don't know what's going to happen with the administration. None of us do. But I think the best thing we might be able to do here is help mitigate against some of these considerations. That's an overview, and I'm happy to take any questions to the degree I can answer them. If we're unable to answer them, we're certainly happy to assess and then circle back with members. I did vet this as well through a couple of the physicians we work with to see if there was concerns that they had. I think there was some limited concern about their ability to treat patients, and I know Speaker and I are chatting with other folks about that as well, but really the goal is to minimize harm to people who are in these facilities over the course of the long term. The last thing I think any of us want to see is a death in one of our facilities because care was cut off.
Thank you very much for that presentation. We will move to questions, and our first question is from Assemblymember DeLong.
Thank you, Chair. Appreciate the presentation and trying to convey whatever this bill is trying to cover. I'm still not quite sure what you're trying to keep from happening, but you brought up something that actually maybe for me is a bigger issue, is that you're saying you need a law here to stop an agency from taking away someone's drugs, to put it that simply. Is there not an existing regulatory agency in the state that has regulatory authority that can act more quickly than the legislature can in any given 2-year period?
Yeah, I'd argue, thank you, Assembly Member, for the record, Atar Hasibullah, Chair through you to Assembly Member DeLong. I'd answer that there may be entities that could step in. We haven't seen that to date, which is why we get bombarded with the letters when there isn't care that's being provided. To go to the first point about the intent of the bill, it's to prevent against the misuse of federally reviewed products, against that could be pharmaceutical products or other products, as I mentioned, hearing aids or other medical devices, by government entities or government-funded entities, and allows for recourse if there's an intent to use it in a manner that the original designer did not intend or the manufacturer did not intend. Again, we've limited it for our most vulnerable Nevadans, but we don't want to see specific items cut off. I don't believe there's another entity that would intervene. If there was, I'm happy to refer all my cases there moving forward when we receive a complaint. But to date, I haven't received any of those from any other entity. Perhaps there is. I'm not sure who that entity would be.
Thank you. And our next question is from Assemblymember Karas.
Thank you, Madam Chair. Thank you for the presentation. I think this is a very hot topic with the way things are going. We just don't know what's going to happen. My question is on your amendment, number 3. I just would like a little more input on how to procure the medications outside of the institution if Medicaid is pulled in our worst-case scenario. I'm not quite sure how that would work. Is someone from the institution going to go get it? Is someone's family member going to have to go get it? If you could just broaden that.
Chair, through you to Assemblymember Karas. Okay, thank you. And for the record, Atar Hasibullah again. Assemblymember Karas, so the conceptual amendment that's there that we're hoping LCB will be able to work through and define much more clearly, obviously, with the NRS provisions that exist than we currently have, would allow for that individual to work specifically with the facility where they're institutionalized, and thereafter potentially seek that from an outside provider. And I'll give an example. There are nonprofit providers in Nevada that provide free medication that won't end up being covered by Nevada Medicaid for individuals who don't have Nevada Medicaid. And I'll leave it at that. I think we can certainly infer that our nonprofit sector covers a disproportionate amount of the work in Nevada that the government should be doing. But those individuals would be able to work with the facility to be able to procure those items, again, whether that's a medication or whether that's a device that they might end up needing from an outside provider and be able to use in that fashion. But it creates the flexibility that's necessary to be able to do so in a time period when lawmaking, again, is not occurring. It provides for a safety benefit for any of these departments to be able to vet those items as they're coming in, and it precludes the ability for the state to just disregard what care looks like in that regard should an order come through that prevents the ability to access such items.
Thank you. Thank you, Chair.
Thank you. And our next question is from Assemblymember Gurr.
I really hadn't gotten in the queue yet, but okay. I think it was Haiti, or Assemblywoman Kasama that had a question, but I have one now that you've called on me. Thank you. In the bill, what are the exceptions? Oh, no, that's not the question. How will compliance and how will they comply with the restrictions? How will they be monitored, and who's going to enforce them?
For the record, Atar Hasibullah, Assemblymember Gurr, I think that's often a question we have when we're engaging in rulemaking with respect to our institutional facilities. The reality is that there's not always a consistent practice of oversight, right? Much of this happens in areas where there's the inability to see these actions. But I'll tell you from our perspective as an organization that I consider a watchdog organization over government entities that has continuously engaged in litigation with many of these municipalities as well as many of our state entities, including our Department of Corrections, we often will receive complaints directly. I know some members of this body have also, over the course of their careers, received such complaints, right? And oftentimes these complaints make their way over to private practitioners as well. Now, I'll tell you, private practitioners that are lawyers generally are hesitant to take these types of cases on, primarily because there's not a lucrative personal injury aspect sometimes that are associated there. We end up taking these cases on because it's the right thing to do, and we need to establish better policy. So with respect to what ends up happening there in terms of oversight, it would be much the same way many of these existing items are, which is that if someone is aware that they've been prescribed something wrong, and let's say that it ends up going wrong, we tend to receive complaints there, and we'll certainly follow up should that happen. We're hoping that doesn't happen, and the majority of times, one of the statutes that does exist within Nevada requires notification of a lawsuit before one is filed, for instance, against a municipal entity. And at the state level, we tend to give a heads up when that type of action happens as well on all types of different issues when we're dealing with people in institutionalized settings. So I think like the reality of what we experience here on the ground is that we'll end up receiving that complaint thereafter that someone who was in a position where they shouldn't have been prescribed something was, or their drugs were cut off. That's the most common one that I foresee coming, which is that we'll end up receiving a bevy of complaints, potentially from some of you who have constituents in your districts that have family members who are in one of these settings, that will advise us that this person's medication is no longer accessible. What can you do? And from there, it's our responsibility from my vantage point to take some of those on. But again, we work with limited resources as well, so it's a longer-term issue. I think from an immediacy standpoint, though, we want to make sure that in this in-between period, it's not just lawsuit after lawsuit against the state.
Thank you. Follow-up, Chair. So at this point, we don't have an agency. Do we have to stand up an agency to handle these complaints, or is it just simply you get sent to the ACLU, ACLU tries to follow it up and go sue the people who are doing it wrong, but no state agency is involved?
Assembly, for the record, Atar Hasibullah, Assemblymember Gurr, you don't have to refer me any more cases. We have our hands full with it, but I will say we'll take those on. I would say if there was an agency to do it, and there's certainly people that are better equipped to share that. You know, I know there's the ability to engage in oversight to some degree on some of these items, but the state doesn't have an inspector general. We don't. There's a lot of layers within the state right now that don't exist. Quite honestly, I'm not up on all the funding mechanisms that exist within the state. Certainly, many of you are better equipped to say that. I don't know that we have the ability to pay for, some of these other entities that theoretically could. But certainly, from our vantage point as an organization, again, that I reference as a watchdog, oversight's a critical component of that. So that's why we do get involved, and we receive probably the highest concentration of complaints in the state with respect to institutional settings and the conditions that occur there.
Thank you, Chair.
Thank you. Our next question is from Assemblymember Kasama.
Thank you, Chair. My question is, and first I'd like to state, I think we all believe that preventative care makes everything less expensive for us down the road, and so that's certainly very important. My question is, as I read through the bill where we have sections here, like under Section 1, contrary to terms of use, inconsistent with written directions, the examples you're giving are more where it hasn't been provided. This section seems to be talking about inconsistent use, but your examples are it's not getting done, or it's not being. So where in the bill, maybe I missed it, does it talk about it not inconsistent, but it just not being provided?
So again, for the record, Atar Hasibullah, Assemblymember Kasama, so the actual use and the description for many of these items is for long-term use. That was the original design. So when we mentioned heart medication, that's one of the complaints we did receive, right? Specifically, those were to be utilized for the remainder of one's life, cut off. When we talk about hearing aids, in that specific instance on the product end, the ability to have that have a battery in it, right, cut off. But the other item that I'd associate with that too is that if there was a scenario where someone was prescribed, if I'm understanding your question correctly, somebody was prescribed something as potentially a one-off, and it shouldn't be prescribed as a one-off. That, I think, would fall under these sections as well. I don't know if that answers your question.
So what I'm hearing you saying is that, and correct me if I'm understanding correctly, that the inconsistent use by definition would include not being provided.
Yes, there's an auto cutoff here, which is fantastic to know. I didn't know that on my side. Atar Hasibullah for the record. Assemblymember Kasama, letter B, where it's described, and this will carry over obviously to section 2 as well. I believe there are mirroring sections throughout in different areas. But if we look at letter B, and it says inconsistent with any intended usages would come after the or. The intended usage for those, and physicians know this better than I would, right? What's to be utilized for long-term care and what's not. I don't purport to be a physician, right? But those that we've ended up utilizing as experts in these cases over the course of the long term have stated what is to be utilized for long-term care, primarily when we're dealing with chronic issues that are permanent. Another example, preventative cancer treatments that end up coming up. Right? We've received complaints, and I know this body's worked on these issues a lot over the years and attempted to get our law up to speed. But that's another example where a few years ago, and I believe Assembly Bill 282, if I'm not mistaken, from the last 286, one of those from last session, which spoke to incarcerated women's rights and provided for elements there, actually spoke to some of these items as well. But part of the reason why the bill was brought was because there were gynecological exams that were occurring in pelvic exams where there was irregularities and then there was no follow-up treatment that was provided. But we've also heard from individuals that were diagnosed with cancer that didn't have consistent access to their pharmaceuticals long-term, depending on length of the sentence. I'll also mention, we did not ask for many of the individuals who are directly impacted in these settings to come forward with letters of support, and I'm going to explain why. We were told when we've worked on these issues, there's a culture of retaliation, and people are afraid to come forward with many of these letters in these settings. So we're here on those people's behalf to be able to share that information. I'm sure they'd love to if they felt like they weren't going to be retaliated against. But, if you feel like you're going to end up facing a lockdown setting, and again, I'm not saying that's at that may be just an allegation that's shared, right? But the allegation is sufficiently frightening enough for many people to not come forward and tell those stories. So that's why they write us confidentially, because privilege applies.
Thank you. Our next question is from Assembly Member Flanagan.
Thank you, Madam Chair. Good morning. And actually, Ms. Pasabula, you touched on the point I was curious about, and it's the retaliation space. This feels like a first step that is needed and necessary. Do you plan to do more work, I guess, to create a pathway so that they can, because it's one thing to say you can't misuse the product and you need to provide someone with the medication or the healthcare devices that they need. But in the hostility that can exist in these facilities, how do we actually take more steps or use this as a tool that allows for the communication to happen to say, I do need the help without being afraid? Like, it's one thing to put it in place, but how do we see the people actually using the benefit?
For the record, Atar Hasibullah, Assemblymember Flanagan, thank you for your question. There's a lot of work that needs to be done, primarily with respect to issues including retaliation. I won't purport to say today that there's a magical solution in place, right? I think that I'd submit there's many issues involving our institutionalized settings right now, and we've seen that manifest, and many of us have personal stories of friends and family members that have been treated poorly, or in many instances treated in violation of the Eighth Amendment. And there's been claims that have been brought all across the country with respect to that. There's much reform work that needs to be done there. I don't know that we're going to have a solution for that today. Obviously, I think that's a more holistic conversation and a long-term conversation about how we address it. But I will say that we receive, as I mentioned, a bevy of complaints. And one of the beauties of being a civil rights lawyer is you have the opportunity to investigate these instances and provide quality feedback when these items pop up. You're able to do things like subpoena entities and get medical records and go to the bottom and get to the core of what's happening. Not everybody in every setting is able to do that, but hopefully, we'll be able to work towards those solutions long-term while providing at least this modicum of a step towards protecting people in the interim.
Thank you. So this is essentially a first step toward accountability within the facilities, and then it allows some recourse and some support to those who are there.
For the record, Atar Hasibullah, Assemblymember Flanagan, I think this might be a fifth step on a 100-step path forward, right? Or a fifth. There's been many steps, and I know this body has spent extensive time making sure accountability is a top feature. I still exist, and my organization exists because it hasn't hit scale. I'd like to not have a job in that way one day, where the ACLU wasn't necessary when it came to these types of issues, but I'm not sure that that's going to happen right now. So I think we're somewhere along the path, but the path doesn't seem to have an end towards it.
Thank you. Our next question is from Assemblymember Gallant.
Thank you, Chair. Sorry, I got off track. I was thinking about a world without the ACLU, what that would look like. I'm curious because on one hand, I feel like you are trying to ensure that there is continued care and access to medicine. And on the other hand, there seems to be this other portion of this bill that talks about maybe an increased liability for using medications off-label, which seems to be a very standard practice in the medical field. I'm not a doctor, but I have spent years working on them as a therapist. So how is this going to increase access when you're limiting and increasing the liability to off-use label that is pretty common in the medical industry?
For the record, Atar Hasibullah. First, Assemblymember Gallant, thanks for the question. I know you'd be gravely disappointed in a world without the ACLU. But with respect to your question and accessibility, I think what we're trying to do right now is solve for some of these issues that we're expecting are going to come in the interim. I mentioned specifically items that have been utilized in a manner that was not consistent and that were cut off. But we can also speak a little bit, and I don't want to delve into too many details, but individuals who are in an extremely hot setting being prescribed specific medications when they're not supposed to, right? I could go down the bevy in the laundry list of the issues and complaints we've received. My goal today, though, is not to share all of that information for two reasons. One, confidentiality rules that I'm required to maintain, but also the goal is not to view this as a negative on the state. We know the state has a lot of issues. I view this as a protection of liability against liability for the state, primarily because if something ends up happening, again, the state's going to be on the hook. And that's part of the reason why we mention accountability. Anytime we sue the government, it's not as if the government is being funded by some other entity outside of taxpayers or outside of the specific sectors that are taxed. So we're taking money out of our own pocket. It's not our preference to do. We don't have a choice but to do it. That's the remedy that's afforded along with injunctive relief that requires something. In these types of settings, injunctive relief doesn't normally come that quickly. Courts don't move even in emergency settings as fast as we'd like. So our hope is that we actually limit liability for the state by doing this, by ensuring that use is conforming in that regard, and providing an outlet for that to occur. There is obviously the ability to notify the product's patent holder, manufacturer, distributor, and say, hey, we're going to be utilizing it in this fashion and seeking approval in that fashion in these limited settings. The other thing I'll mention as well, we have heard, I know the speakers heard, there's misuse of many products. Our concern primarily, though, is with our most vulnerable community members right now that are in the care and custody of the state, where liability is automatically going to end up imputing to the state, period.
I do have a list of questions we will be going around, but for time, I want to make sure everyone gets at least one question. So our next question is from Assemblymember Edgeworth.
Hi, good morning. Thank you, Speaker Yeager, for bringing this up. Getting appropriate medical care is important for everybody, incarcerated or unincarcerated. As somebody who has treated people without access to medical care and people with Medicaid that are unincarcerated, those are the people that I've treated, it is common that there'll be inconsistent use of medications. It's not uncommon that off-label use medications are used or devices may not be readily available to people with Medicaid who are unincarcerated. Things like that happen a lot. Is it right? I don't know. But can I just ask if, at its heart, if this bill is asking for people to be getting the same care as unincarcerated Medicaid recipients, we're not talking about getting more care or different care. Is that correct?
For the record, Atar Hasibullah, Assembly Member Edgeworth, yes, that's correct. This wouldn't be additional care, but as I mentioned, the reality with respect to potential Medicaid cuts, and you know this likely better than I do, on the pharmaceutical end, we recognize certain items will not end up being covered through Medicaid, and that becomes an issue if the FDA approval still exists. So you'll have the ability to still have those drugs available, those medications available, but the government's not going to pay for them. And when you deal with a population concentration that only and exclusively, to my knowledge, maybe there's exceptions that are out there, utilizes Medicaid, but those items are not covered. We want those individuals in the meantime to be able to have access to those items. So it wouldn't be more coverage, it would be the ability to have equal coverage and medical care as if they weren't in that setting. To us, that's a basic fundamental philosophy. We should not have anybody harmed. That's within the custody of the state. Again, not only because it's the right thing to do, and that's what Nevadans and all Americans should want, but because the liability aspect that would fall and encumber the state at that point would be significant.
Thank you.
Thank you. Our next question is from Assemblymember Jackson.
Thank you, Chair. Thank you for the presentation. I am not a doctor, a lawyer. I know this was probably mentioned earlier, but just if possible, in the most basic terms, how does this bill make sure that government uses these products safely and correctly?
For the record, Atar Hasibullah, Assemblymember Jackson, the bill, if I was to paraphrase this and simplify this, if I was doing a 20-second Instagram reel or something on some other social media platform, I'd say this requires government entities that have prisons, that have mental health facilities at the state level, to make sure that the drugs or the items that they're using are consistent with the designer's purpose for it. They're not off-labeling everything and running amok. And then on the back end of it, making sure the devices are being utilized and being provided in a manner that's consistent as well. So when I mentioned the hearing aid batteries, that's one that really came up, right? Somebody asked for their hearing aid batteries they stated, for over a year before they were provided. This person couldn't hear for a year. These are not normal types of issues that we often end up seeing. And so for our most vulnerable folks that don't have access and a lifeline to immediately make 100 phone calls and have money to get an attorney on the line right away, these are the types of issues they faced. It's certainly not easy for them, but from a medical care perspective, we think the least we could do is help mitigate against those concerns in the meantime.
Thank you. Our next question is from Assemblymember Goulding.
Thank you, Chair. I appreciate the layman's explanation. That would have been helpful in the beginning, actually. Because I've been struggling with, are we talking about concerns about the cost, or are we talking about misuse? So I want to start, the beginning of the question is, who pays for medical care for incarcerated people? Is that always Medicaid?
For the record, Atar Hasibullah, almost always Medicaid in the state. There's been other bill presentations with respect to debt that's also been incurred on the back end. Those are separate bills, but yeah, it's almost always the state. It's going to end up being the public because, generally speaking, private health insurance is not going to end up being available or affordable, and we don't have statewide universal health insurance coverage, which I know Assemblymember Gallant will probably be bringing a bill to support in the near future. That's a joke.
So is the concern about coverage, the cost, or is the concern about abuse?
For the record, Atar Hasibullah, there's two simultaneous concerns. The first is about abuse. That's an issue that has existed for a period of time, as I mentioned. Items not being given that are properly given, items not being dispensed in the way that they were intended to be dispensed, including for long-term care. It's First issue for abuse. Second issue for coverage. When I'm saying coverage in this instance, if Medicaid comes, or if the federal government comes with specific cuts to Medicaid and says something is no longer covered through Medicaid, that will no longer be available within many of these facilities. And the individuals at that time who are seeking these items are not going to have the ability to readily do so. I'm sure at some point the Department of Corrections is going to end up saying, well, we're working on it, we're trying to get this together, but they're going to unfairly be blamed at that point for provisions that don't currently exist in law that tell them that, hey, this is fine. They're able to access these items outside of this specific facility through a nonprofit provider that will be able to cover these items that will now still be available. Again, FDA approvals probably, from our vantage point, they may or may not be rescinded, but we don't think that's going to happen in the same way in terms of likelihood as a cut towards Medicaid and the inability to have that. So previously, Assembly Member Edgeworth had asked a question about equal care. That's what we're trying to do, provide the ability for those individuals who are in these facilities to have parity with respect to what they can receive and not be in a position where they don't have them. So it's both. It's not either, because both of these items with respect to accessibility of a medication, which comes via coverage through insurance, and secondarily to mitigate against abusive practices or abuse that occurs with respect to both pharmaceuticals and devices, would also be covered within this specific bill. At least, from our vantage point, the foresight that's associated with it will help to mitigate against it. We don't know what will happen, but we think that at least from the vantage point that we're operating with and the concerns and complaints we've received over the course of time, this could allow for that and then mitigate against the state's liability when that does not happen. Because make no mistake, that's what is likely to happen. If something ends up cut off that was for consistent use, there's going to be an immediate rush to deal with the state in that regard. And the response that the federal government cut off Medicaid access and there was still the ability to be able to procure these items, oftentimes, from my vantage point as a litigator, those are harder arguments for the state to make in court. So I'm not going to make the state's argument for it in the event we have to litigate, but I certainly think that that's one way to help prevent against that.
We've gone through the committee, everyone's had about 2 questions. So what I would like to do is I have 3 more questions. Each person, please, 1 quick question each. Thank you. And we will go back to Assemblymember DeLong.
Thank you, Chair. It is a quick question. Have you tried to work with the chief law enforcement officer in the state of Nevada, the Attorney General, on these issues, on trying to get things addressed?
For the record, Atar Hasibullah, Assemblymember DeLong, we have worked extensively with the Attorney General over the course of his tenure as AG and certainly during the last 4 years when I've been leading the ACLU on a bevy of issues. But I will tell you that the Attorney General's office's responsibility is to protect the state. That's the responsibility. Our responsibility is to make sure that civil rights issues are addressed, and sometimes that puts us at odds on some of these items. So I do know that they try, and the Nevada Department of Corrections and the director has tried to accommodate on many, many issues. But we also know, and we've seen this play out many times in these types of hearings, that there's been significant issues that continuously get raised with respect to these facilities. So yes, the Attorney General has been involved on many of these items, but oftentimes what will end up happening first is a lawsuit will prompt that overlap.
Thank you. Our next question is from Assemblymember Edgeworth.
I'll keep it brief. Thank you, Chair. I think we can all agree that in the state of Nevada, there's a real paucity of practitioners. In the state, we're at the lowest numbers per capita. I'm sure that that's reflected in the incarcerated system, that there aren't very many practitioners who are willing to work in that environment. Are you concerned that this bill might add to a perception that there would be increased liability, thus less practitioners would be willing to work in this kind of environment?
For the record, Atar Hasibullah, Assemblymember Edgeworth, I appreciate the question. I'd actually offer it's the exact opposite. The ability to mitigate against off-label use and consistency with respect to prescribing at that point, as well as requiring the department to work with the individual who doesn't have access, precludes potentially in many of these instances the physician from being blamed. That's not what we want to see. And this provision, primarily with respect to the amendment, if the items are cut off during the pendency of the next 18 months, may allow that practitioner to thereafter say, There is a policy in place where this can be accessed. This is the item that's there, right? And that's why the amendment ends up existing in that fashion. So I think it actually precludes against liability or helps mitigate against some of that in that aspect. And that's why we're advocates for it as well. We do need more physicians in the state. And again, we encourage all legislation that supports that as well, because that population is very underserved when it comes to proper health care and treatments being received.
Thank you. And throughout this, you've answered all of my questions, but we do have one last one from Assemblymember Flanagan.
Thank you, Madam Chair, and thank you, Mr. Speaker, for bringing this bill forward, and to Atar Hasabullah of ACLU for being here to help us understand it better. The charge is to fight for those who are underrepresented, and so thank you for doing that. And is there any consideration in this bill space? Because my concern is that there's no entity to monitor whether or not this is taking place or to help this work better. Like, it's great to put the protections in place to say you need to help these people provide their medications, provide their devices. We've talked about retaliation. Is there any consideration of adding like that additional layer, or going forward having that layer where there's an entry point for the incarcerated person to say, I'm not getting this, or to monitor how it's working?
I had it on. I will say that time. For the record, Atar Hasibullah, Assemblymember Flanagan, with respect to that question, look, we'd love to see something like that. There's also the practical reality that we've seen the budget, and our ability to add items that would introduce new offices or new variables there probably wouldn't be well received. So I would love to see something like that happen holistically. I'm not sure that's in the cards for this particular legislative session, and that's just based on where the projections lie. Obviously, I know that many of you are grappling right now with other considerations in terms of what to fund and what not to fund. There is going to be a gap in terms of Medicaid coverage potentially with respect to what comes next, and we've been tracking those as well. But as it stands right now, we'd love to see that happen. That's, I think, a long-term project to add accountability to the state and additional oversight in that regard. But where we stand right now, we think this is at least a positive step, again, from a mitigation standpoint.
I just want to say thank you for the strong effort, and I just want to put that on the record that.
Thank you, and if I could just add, Madam Chair, first of all, thank you to Mr. Hasibullah. Always bring somebody smarter than you to the bill presentation. I think I've done that today, but, you know, I think part of what we do here is we pass these laws, right? And this is the first step. What typically is going to happen is if this gets enacted, the institutions that it will apply to, I mean, their legal counsel is going to look at it. And usually we would expect to see some regulations come out of how this is going to work. Those are generally proposed by the agency. Those do come in front of the Legislative Commission, which meets in the interim to approve those. So I would think like that would be a good first step, because if this passes, whoever it applies to is going to have to decide how are we going to actually implement this and what procedures are we going to put in place. So there is that rulemaking process that would happen between legislative sessions. Obviously, you know, nothing we do here is ever perfect, and so that's why we have so many cleanup bills that we do year to year. So if this were to be enacted, and I think that's something we could potentially look at to see how it works in the interim, and if there needs to be additional structures or guidance or programs or accountability, that's something we could build on the next session. But I think it's a good first step to getting the requirement out there and seeing if it can be complied with, and hopefully we don't have to step in, but if we do, I think that's what we hopefully do in the 2027 legislative session. Thank you, Chair.
Thank you, and thank you for your presentation. If any committee members have additional questions, please reach out to the sponsors directly. And we will now move on to testimony. Testimony can be provided in person in Carson City, via video conference in Las Vegas, or over the phone. Further instructions for providing testimony on a bill can be found on the agenda. Each person has 2 minutes to provide testimony, and please keep remarks to the point. We will begin with testimony in support of AB 208 here in Carson City. Please come up to the table and begin when you're ready.
Good morning, Madam Chair, members of the Committee on Assembly Government Affairs. My name is Brian Wachter, W-A-C-H-T-E-R. I serve as the Senior Vice President of the Retail Association of Nevada. We are in strong support of AB 208. We view this as a way to protect our members and the hard innovators that are manufacturing, designing, and creating our products that you enjoy. We want to make sure that those are being utilized in a way that's intended. You heard from the bill's sponsors in the presentation that oftentimes there is a lot of pushback on those inventors and those companies when those products are utilized incorrectly. Do want to address the off-label medication issue with the amendment, speaking on behalf of our pharmacies. It is a standard operating procedure for those medications to be used, and it's such a it is such a regular thing to be used that we wouldn't actually find there would be a lot of instances where that manufacturer would say, no, please don't go ahead and use that product in that way. It's only in those instances where that manufacturer is putting a red flag saying this is probably not something we want our brand associated with, that we should probably pay careful attention to. And so with that, we're happy to support the bill and we look forward to its passage.
Thank you. Is there any other testimony in support here in Carson City? If not, we will move to Las Vegas. Is there anyone wishing to provide testimony in support for Assembly Bill 208? Seeing no one approach, AVH, is there anyone on the line?
If you would like to testify in support of AB 208, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to participate at this time.
Thank you. We will move on to testimony in opposition. Is there anyone in Carson City wishing to testify in opposition to AB 208? Please go ahead when you're ready.
Thank you, Chair Considine and members of the committee. Leah Cartwright, L-E-A-C-A-R-T-W-R-I-G-H-T, here today on behalf of the Nevada Psychiatric Association. You should see their letter posted as an exhibit online. I won't go into too much detail. There have been some conversations already about, the off-label prescribing. During this committee hearing, I've heard a lot about these are the most vulnerable, they're the incarcerated, they're the folks who, they're in state custody. If you review the amendment where it refers to mental health center pursuant to NRS 144 and a facility providing mental health services pursuant to NRS 433.233, that includes both NAMS, SNAMS, and the rural clinics and Lakes Crossing. Lakes Crossing is a locked facility. You are incarcerated there. NAMS and SNAMS do have inpatient facilities, but they are also outpatient. They provide outpatient care. Rural clinics are almost exclusively outpatient care, and rural clinics also oversee our mobile health crisis response teams. So as currently drafted in the amendment, we still have concerns that this would be overly broad and cover those moments where psychiatrists are trying to intervene in maybe a less restrictive manner. So one example that I've been given is the use of propranolol, which is a blood pressure medication, but it is used off-label for the treatment of anxiety. There are several others. I am not a doctor. I can find several psychiatrists who would love to come and chat with you about this, and we are working with the sponsor and the ACLU to find a common ground here. I just wanted to make sure that all of the progress that we have made as a state in increasing access to medications is not hindered in this moment. Thank you.
Thank you. Is there any other opposition here in Carson City? Okay, moving to Las Vegas. Is there anyone wishing to testify in opposition to Assembly Bill 208? Seeing no one approach, AVH, is there anyone on the line?
If you would like to testify in opposition of AB 208, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to participate at this time.
Thank you. We will now move to testimony in neutral. Is there anyone in Carson City who would like to testify in neutral on Assembly Bill 208? Seeing none, we will move to Las Vegas. Please begin when you're ready.
Hello, good morning. This is James Zurenda, DZURENDA. I'm the Director for the Nevada Department of Correction. First one, hearing this testimony, I just got to clarify that Medicaid does not pick up our medications in the Department of Correction. It's actually against the law for Medicaid to cover those expenses unless it's within the last 90 days of release. But anyway, also I just wanted to bring up what is a formulary. A formulary is approved medications that are out there for specific diagnoses that are common. And if there's an uncommon diagnosis, it goes through a panel of doctors. Some are in the Department of Corrections, some are not related to Department of Corrections, to make it impartial to determine the regimen for medication. And that if it is not on the formulary, they will determine whether or not there's other medications that exist that can actually be used for treatment of that medication. However, the doctors have to go by the formularies that are used for certain specific diagnoses. So those formularies are in place. If it's a question about the formulary with the medications are wrong for those diagnoses, I guess, is that really the issue? But the medications that are on that formulary are already approved and have been approved for many years for those specific diagnoses, unless new medications come aboard. That's all I have.
Thank you. And AVH, do we have anyone on the line for neutral testimony on AB 208?
If you would like to testify neutral on AB 208, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to participate at this time.
Thank you. Would the presenters like to make any final remarks?
Steve Yeager for the record. Thank you so much, Madam Chair, members of the committee. Hearings like this make me extraordinarily proud. Very good questions, and I think the goal here is obviously to try to get a bill that accomplishes what we're trying to do. I want to thank Mr. Hasibullah, who you noted did most of the heavy lifting in this hearing and answering your questions. We do believe that some of the concerns that were raised can be addressed. There can be some further narrowing of that amendment to really get at what we're trying to get at. But ultimately, I think one of the things that we talked about a little bit here but didn't come out quite as much is trying to limit the state from liability, right? Trying to limit the state from being sued for doing things they shouldn't do or for cutting off medication. I think that is a value. When we look at the budget, we don't have extra money for that sort of stuff. So I want to thank the committee for the consideration. I think Assembly Bill 208 is a necessary step towards ensuring responsible management of federally reviewed products and facilities that serve the most vulnerable Nevadans. I think it provides clarity, transparency, accountability, while safeguarding both patients and institutions. Certainly willing to work with any member of this committee who continues to have concerns. I took very detailed notes of your questions and your concerns, and myself and Mr. Hasibullah would be happy to try to address those in any way we can, and just simply ask for your support on Assembly Bill 208 moving forward.
For the record, Atar Hasibullah, I got the green button to work finally at the end. So thank you again for indulging me. If anybody has additional technical questions, whether they're a legislator or a lobbyist or someone who's just interested in the issue, you're welcome to reach out to me. Happy to answer questions to the best of our ability. And I did want to thank the speaker for bringing this on behalf of the people who would not be able to speak up for themselves.
Thank you very much. I will close the hearing on AB 208. The last item on our agenda is public comment. As a reminder, members of the public can provide public comment in person or telephonically and may submit written public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. Telephonically, you can dial 888-475-4499. When prompted to provide the meeting ID, enter 844-5965-8155, and then press pound when prompted for participant ID. Each person will have 2 minutes to provide testimony. Please remember to clearly state and spell your name for the record. Is there any public comment here in Carson City? Seeing no one approach for public comment, is there anyone in Las Vegas? Seeing no one approach, AVH, is there anyone on the line for public comment?
If you would like to participate in public comment, please press star 9 now to take your place in the queue.
Good morning, Chair, Assembly members. Jason Gibson with the House of Gibson, post-political prisoner, ran for District 1 County Commissioner here in Douglas County, was unjustly incarcerated. In order to take me off the ballot, they misidentified and mischaracterized me as being mentally incompetent. I was arrested at Tahoe Justice Court on August 5th. I served 42 days in their inpatient treatment program and was released on September 17th under the auspice of an inpatient treatment program. What it essentially is a high security 23/7 lockdown where you're stripped of your inmate rights and your constitutional rights and your right to exercise and be of health. In order to be released, I was subject to medication. They call it medication. What they did is they inflamed my they disrupted my disequilibrium of my body. My skin was on fire. I could not sleep. I had head congestion, and so I still have insomnia. And it was unbelievable that you folks are funding these kinds of programs under the auspice of a treatment program. They call this mental health treatment. It is nothing more than domestic terrorism. And I've seen what they're doing in this pharmacology business and how they destroyed my parents with the same. And I'm here to tell you that what's going on in this state is absolutely criminal. And they're going to try to do it to me again next Tuesday. I was falsely accused at a board meeting for alleged harassment, for speaking like I'm speaking to you now. I haven't harmed anybody, haven't hurt anybody. I've never struck a woman in all my life or anybody that didn't deserve it if I wasn't defending myself. Not a criminal. I'm
Thank
55
you. I'm
years
sorry.
old. I grew up in
Your
this
2
county. 40
minutes for
years in this
public
county.
comment is up. Would you please wrap up?
Thank you very much. I appreciate it. And I appreciate this back office. It's a really efficient and clean way of dialing in. And thank you for giving us a voice.
Chair, you have no more callers at this time.
Thank you very much. The next meeting of the Government Affairs Committee will be on Monday, March 3rd at 8 a.m. in room 4100. That concludes our meeting today. The meeting is adjourned.